there is a bit of give and take. So we feel that the rise in the default limit is which may not be above the 1 crore limit. Now, of course, there have been quite a few judicial pronouncements that the IBC is not intended to be a recovery mechanism. And while that is well and good, the fact of the matter remains that as a matter of practice, it has been an excellent tool to sort of have some kind of discipline as far as payments are concerned in the market. It has been being used as a matter of practice to get some recoveries as far as operational creditors are concerned. While the increase in a sense is welcome in terms of a measure of protection, it will also not bring in cash into the hands of small businesses, or rather the IBC cannot be used as a tool to put pressure as far as that is concerned. We now sort of turn to what the impact of this rise in the default limit is going to be on various kinds of stakeholders. Firstly, those who are sort of involved in the practice of insolvency itself, insolvency resolution professionals and legal professionals in the insolvency sector. I think there is going to be possibly a downturn in the work that's there. But at the same time, I think the earlier default limit was already set at a very low level, which meant that the infrastructure that has been set up, the adjudicating authority, the appellate tribunal, were clogged with a lot of cases. So we feel that this is going to be a welcome step to sort of declog the pipeline in a manner of speaking. So in that respect, this is a good change that has been brought about. As far as employees and workmen are concerned, I think they will be a little hard hit by the change, because earlier we did see cases of employees bringing IBC actions or sending demand notices or filing petitions for recovery of their unpaid salaries and unpaid dues. That will probably come to a stop because they will not really be in a position to leverage the IBC to get their money out, because in all likelihood the dues will be below the 1 crore limit. Other operational creditors, like I said earlier, are also likely to be similarly constrained. Financial creditors, we feel, are not likely to be as badly affected as some of the operational creditors, because a lot of the defaults anyways would have to be above a certain limit for financial creditors to be involved. And although it has to be said that not every default will trigger the IBC. Earlier, the limit was only at rupees 1 lakh. So the default with respect to a single installment would also attract the provisions of section 7 of the code, but that may not be the case anymore. So you would have to have multiple default of multiple installments accumulating to 1 crore as if the loans were of a smaller size. One interesting category that Aparna and I were discussing was the home buyers category. They are also a stakeholder, and they have also been interpreted to be financial creditors. Then there was an amendment to the IBC last year, which brought them in as a financial creditor formally. And there was also another amendment that said that standalone home buyers could not initiate IBC. Now, you have to have a group of about 100 individuals who could together move the adjudicating authority, the NCLT, against a real estate project. Now, possibly there's a element of blessing in disguise here by the rise of the default limit. because a standalone uh, home buyer was unlikely to cross the 1 crore limit if he was all by himself. But if the default limit is read cumulatively, which it is likely to be the interpretation, then we feel that most home buyers who can group together will be in a position to continue to move the insolvency and bankruptcy code as far as real estate projects are concerned. Lastly, secured creditors may not be as badly affected because they will continue to be able to resort to the not only the IBC if the default limit exceeds 1 crore, but also other avenues like the Securitization Act. Now, moving on to our next topic, as it were. One question which I have to answer before I move on.
Sorry. Yeah. No, sorry, Arjun. Go ahead. There were two questions in the chat box, which I thought one of them is quite interesting. It says, is the 1 crore limit applicable retrospectively?
So I think it's a substantive change because it's the pivot on which the IBC applies or it doesn't apply. So my interpretation would be that it will not be a retrospective change, but it would be a prospective change. But there may be some questions on how exactly that line is drawn and where that line is drawn. So some care may have to be taken there because, for example, in the case of financial creditors, the default itself is the trigger. So therefore, I think that overall it's going to be a prospective change, but nevertheless, one has to be really careful as to how that line is drawn. So that would be the answer as far as that question is concerned. And there was anything else, Aparna?
Yeah, this one is more, I think, of a point which says that the increase is unlikely to affect financial creditors because they have a significant long-term relationship. But what about operational creditors use since the limitations are also being extended?
Right.
I'm not talking about, yeah.
Concerned, I mean, we don't address the time periods would sort of stop or cease to move forward. This was for all commercial suits, all actions, or even appeals for that matter. Now, an appeal from the order of the adjudicating authority, the NCLT, to the NCLAT has to be filed within a strict time period of about 45 days. But I think that those time periods are now sort of automatically extended or waived till we get to a situation where there's some kind of normalcy and an order is passed saying that we have reached that point. So people need not rush to court, as it were. Then there was also an order passed by the National Company Law Appellate Tribunal, which was along the same lines as the Supreme Court order, but it said that the timelines under the code would be extended and all interim orders that had been passed by the tribunal would continue to operate. This was followed by an amendment to the CIRP regulations, both and also the liquidation regulations, which officially sort of gave a statutory sort of seal to the extension of the timelines. So what this essentially says is that if there is any timeline mandated, and there are several timelines mandated under the Act for the insolvency resolution process, and even the liquidation process has timelines, all of these stand extended till such period as the lockdown is in place. What this has essentially meant is that we, as practicing lawyers, we found that one of the main drivers, as far as any given case was concerned, was these timelines. So it was almost like you had to get to the bus stop and catch the bus Otherwise, you would sort of miss the bus altogether. There were no second chances under the IBC for many things. So that has been suspended, and I think what that means is that it has sort of taken the urgency of the way in which the code was being worked. Um, there is also, we feel there will, of course, this will have an impact on the ongoing CIRPs, that is the corporate insolvency resolution process, and the ongoing liquidation matters. So I just wanted to reach out to you, Aparna, and ask as to what are your thoughts on how this will play out uh, on ongoing matters.
Yeah, so I think ongoing matters, this will definitely make them go a little slower, partly because some of the actions that have to happen during the insolvency resolution process or liquidation process, it may not be possible to take some of those actions in view of the lockdown. But the other issue that also comes up, I think, is that NCLTs and NCLAT are currently only hearing urgent matters. So in light of this particular amendment, I think it may also be harder for petitioners and parties to push for a particular case to be heard for ongoing matters as well, given that now the timeline has been extended.
And I believe, Aparna, there has been some development in this respect as to what constitutes an urgent matter or an important matter. Yeah, we at least we've heard that there is some news that the ministry has been writing, I think, to the banks.
Banks, yeah, that's right. So there was, and this is actually also to do with, there have been a lot of matters that are pending admission at the time that the NCLTs did go into this once the lockdown was announced. And of course, the longer, and some of these matters have been pending admission for quite a few months already. And of course, the longer they're just in this limbo, it could have a detrimental financial impact. So I think this was the background in which I think the MCA actually did send a notification to banks suggesting that for defaults or account sizes over a certain threshold, it could consider, saying that these are urgent matters and pushing for them to be heard, at least in order for the matter to be admitted.
Right. And the other thing, of course, is that there are still quite a few resolution plans that are pending approval at either at the COC stage or at the stage of approval by the adjudicating authority. What do you think is likely to happen in those kinds of cases? Do you think there, because of the fact that there's not so much optimism in the market and people want to hold their cash close to them, people may want to back out of resolution plans? Is that a sense that we're getting, or a possibility?
Yeah, I think that is a sense we are getting from many market participants, that a lot of resolution applicants may not, especially at this time, even if they don't want to pull out completely, they may not want to go ahead until there's a little more clarity. And I guess this is kind of a double-edged sword, because in one way, because the timeline has been extended, it is possible for COC to decide to extend the timeline for, say, submission of a resolution plan or an expression of interest. At the same time, if a lot of resolution applicants do back out, we are likely to either see more liquidation rather than resolution. Or the other possibility that some people have also been talking about is, one thing is that in light of 29A and the restrictions over there, it's unlikely that promoters in very many cases will not be able to bid for their own assets. So in that, and cannot be a resolution applicant, in that situation, some lenders may also see if a one-time settlement is possible and withdraw the application under 12A.
Yeah, I think creditors would be keener to, if a reasonable offer is on the table, to sort of, there would be incentives to agree to take the money that's there on the table.
Absolutely, I think that's probably the case.
The next thing, and there is still a lot of doubt as to how this is what form this is going to take, and of course, we are still None of us have actually seen the document which is being mooted, and it is still, I think, being worked on and has not been finalized. But there have been quite a few news stories about this. So it's something that's definitely been mooted by the government in the Insolvency and Bankruptcy Board, and that is the suspension of sections 7, 9, and 10 of the IBC. The rationale for the proposal again is that because the next 6 months are likely to be quite tough for the economy, there need not be any needless insolvencies and consequent impact on the market. So this really, I think, what this would mean is that there would be no new insolvency filings that would take place. But what is interesting in this, Aparna, I thought is that at least from what we are seeing so far, Section 8 has not been talked about. That so it will continue to be in operation. So operational creditors will possibly have an opportunity to continue to send out that demand notice. Of course, it will still be subject to that 1 crore threshold that we were talking about, but it will not necessarily lead to an insolvency action, or rather the creditor will get some breathing time to actually sort of collect his funds if he has not disputed the debt, so that as and when the embargo is lifted, he can then actually or he has that time to pay off the debt, as it were. So that's something that's interesting. The other thing is, of course, from what we see, this is not a complete halt of all matters, right, Aparna? In terms of only new filings are going to be stopped.
Yes.
And it's also, I think, that this is not going to. There's no move to actually halt proceedings in other avenues such as the DRT or the Sarfazi Act in the DRT, of course. And so securitization actions will possibly continue, and secured creditors will continue to do what they have been doing.
Yeah, so just to add to that, I think that's right. So for financial creditors, especially secured financial creditors, are likely to have other avenues for recovery, though I don't know if that is the intention of, or whether in that case the ordinance would achieve its intended aim, because the IBC at least offers an opportunity for resolution, whereas in this case, what would be permitted instead is just debt recovery or enforcement of a security interest, which it could be argued could have an even more detrimental impact on the borrower if it's allowed to continue at this time. Of course, the other, and I think this answers a question that Neeraj has asked. He says that if it seems that Cabinet has approved suspension of filing under IBC, once the ordinance is out, what do you think would be the optional recourse for creditors? I think these other security enforcement actions is one. Of course, out-of-court restructuring is the other option for financial creditors. For operational creditors, I think they are going to be quite significantly impacted by this, because, as Arjun said, they were using this previously as a tool to at least get the debtor to come to the negotiation table, agree to a settlement, to have some kind of discipline in payments. So if this ordinance results in basically a reason, makes it much easier for parties not to fulfill or satisfy their payment obligations, then that could be a dangerous cycle we see. But of course, the thing is, we don't really know what form this ordinance is going to take. Also, it looks like it's going to be for all defaults. So it doesn't seem to be restricted to defaults that happen prior to, after March 1st, basically. So this means that even if a company has defaulted a year ago and then there were plans to take it to IBC, it looks like those kinds of actions will be suspended as well. again, we'll have to look at the fine print to see.
Yeah. Aparna, there's just a couple of questions in the Q&A, and that's about, the rollback. So is there going to be a rollback of, say, the default limit? What is our take on that? I personally feel that the 1 crore default limit may be to stay. If it is rolled back, it will not be rolled back to the limit that it was. I think if it is rolled back, you will see it somewhere around 50 lakhs or something like that, halfway, but not all the way down back to where it was. That one reason is that it was already at a very low level, and we were facing issues of delays, etc., as far as the timelines were concerned.
I think that's right, Arjun. That's how I see this particular limit as here to stay, because this has also been recommended in the past by other committees who've looked at amendments to the code. And, there was always the idea that even though it was enacted with this very low limit, that it could be increased later on. So my own view as well is the same, that it's likely here to stay. Just one other point, just coming back to the ordinance itself, which is interesting, is that they've only been talking so far about suspension under 7, 9, and 10. There is one other insolvency proceeding that has been notified under the code as of December of last year, which is against personal guarantors. And though that is not a proceeding under section 7, 9, or 10, it would be under the personal insolvency laws. I think it's section 122 or 123. Yeah. So that is going to be interesting, what happens to those proceedings in two different cases. One is, of course, if a proceeding can just be initiated against the personal guarantor, when there is no other proceeding going on against the principal borrower or corporate debtor. And the second case is, if a CIRP of a corporate debtor is ongoing, then is it possible to initiate, which means, that will be allowed to continue regardless of this ordinance. In that situation, could you actually initiate a proceeding against the personal guarantor? Again, this remains an open question until we see the ordinance itself.
And of course, I think personal guarantees are something that we have seen quite a lot in transaction documents. Whenever some financing is being given, I think that that is something that's almost been par for the course. That directors' guarantees are sought by the banks or the lenders. So I think that this is something we are likely to see quite a lot of, controversy around, because this is likely to be litigated also in terms of if other provisions of the code get suspended, what impact it would have on personal guarantees, as you rightly pointed out. Should I move on to the next section, Aparna?
I think so. I know there are lots of questions. Yeah. Some are also just, I think, on our thoughts. Yeah. So maybe we can deal with some of those at the end.
Sure. Great.
Yeah, so we wanted to talk about also the RBI's intervention in terms of the asset classification norms. So as you all know, right after the lockdown, a regulatory package was announced, which was intended to relieve borrowers from their debt servicing requirements during the period of, the lockdown. So basically, or in light of COVID-19. So basically, the package granted a moratorium on EMI payments for term loans between March 1st and May 31st. And similarly, for working capital loans as well, it allowed for a deferment of interest during this period. A follow-on to these interventions was also a direction from the RBI that in light of these relaxations that are being granted and the moratorium, the asset classification norms wouldn't apply during this period. So it wouldn't be necessary to basically downgrade the asset classification. This would not be considered a default, and so it wouldn't be necessary to change, it wouldn't be possible to change the asset classification during this period. This has led to some confusion, as can be seen in two recent orders, one of the Delhi High Court and one of the Bombay High Court. And the confusion primarily related to those cases where a default had occurred prior to March 1st, but the account hadn't yet been classified as an NPA, which meant that 90 days hadn't yet passed since the date of the default. So if, and in this case, I think in one of the cases of the Delhi High Court, Anantraj versus Yes Bank, the default had occurred in January. And so the asset had been classified as SMA2. Basically 60 days had passed at the time that this moratorium was announced. So the question was then on March 31st, should the bank go ahead and classify that as an NPA? Or in light of these regulations and this guidance, can it not classify this asset as an NPA? And the bank tried to argue that these guidelines only applied to defaults, or rather non-payments that happen post March 1st and not to pre-existing defaults. However, the court said that the idea here was to basically put a suspension on a change in the asset classification. So the bank could not classify that as an NPA during this period. There's a slightly different order from the Bombay High Court, not entirely contradictory, but slightly different, in Transcon Sky City versus ICICI Bank. Very similar fact pattern, where there was a default again in January and February. And here what the Bombay High Court said is that the moratorium is not for past defaults. However, it said that the bank could not, during the period of the lockdown, not necessarily the period of the entire moratorium, but just the period of the lockdown, it could not change, and for 15 days after that, it couldn't change the asset classification to an NPA. So this seems to be more of an interesting compromise rather than coming directly from the regulations. But after this, the RBI did issue a clarification, or rather slightly revised set of instructions on asset classification that did clarify this to a large extent, which is basically that the whole asset classification norms and the moratorium on change in classification applied to all assets that are not NPA as of February 29th. So if there had been a default, but the asset was still classified as SMA1 or SMA2, then there could not be a further downgrade in its classification as long as the moratorium is in effect, basically until June 1st. On the other hand, if an asset is already an NPA as of February 29th, then the banks would continue with their provisioning in the normal course. The only other point to mention here, also another change, is the RBI's circular on the resolution of stressed assets and prudential and classification of asset classification for stressed assets. Under this circular that came out in June 2019, banks were required for larger accounts where the default was, I think, they would have about 30 days to review and decide whether to proceed with a resolution plan outside the IBC and the resolution plan, failing which they would have circular plan accounts to the circular comes about and filings cannot be initiated. But so far the only line
in the Q&A so that it comes up and we can answer that. Yeah, sorry, Aparna, please continue.
Okay, I think that was all on this, unless there were specific questions. Arjun, that you wanted to add on?
No, I think we'll move on to the next because I think we're also sort of running out of time, so we need to be really careful about that. The only thing I will add to this is that the Transcon Sky City order is interesting because it recognizes that there will be a graded lifting of the lockdown, and it's not likely that it'll all just disappear in one day. And it does talk about a complete lifting of a lockdown, and that's the sort of interim order that's been passed in that case. Right, Aparna.
Okay, so here I just wanted to, we won't spend too much time on this, but this is just to note that similar changes are happening in other parts of the end of the regulatory changes that are being made to the IBC. First of all, the ordinance itself is something that's lying there. We're not quite sure what form it will take. So just to explain some of these changes, some jurisdictions have increased the initiation threshold. And one other change that has come about in many countries which had this kind of regime was a suspension of director liability for wrongful trading. So in many countries, including the UK and Australia, Germany, Singapore, all these countries, a company actually was mandated to file for insolvency based on certain tests, not necessarily one default, but if the company was insolvent in the sense of being unable to pay its debts as they fell due. And in this situation, directors did have liability if they continued in the ordinary course without recognizing this. And this is what is called wrongful trading when you're in the zone of insolvency or in insolvency. So this directors no longer the suspension. So this kind of director liability has been suspended for a limited period of time. So there is no obligation now to voluntarily file for insolvency in this situation. The other interesting change that some jurisdictions have done, some of them have said no initiation of insolvency, not as in a blanket sense in all cases, but against specific kinds of businesses, such as Singapore has done that for small and medium businesses. And Germany had another interesting change, which is that for creditor-initiated insolvency, any defaults that had occurred after March 1st, which I guess is sort of the proxy for a default that has occurred in light of, the pandemic and the economic stress that it has induced. Only in those cases, the insolvency could not be initiated. But in other cases, for past defaults, they could still continue to do so. So this is just a flavor of some measures that other countries have taken. I think, Arjun, do you want to add to this, or we can go to the last?
Yeah, I think we should move forward.
Yeah.
So, Aparna, here we talk about what are the other things that we see going forward in the market, and of course, out of court restructuring is something that we are likely to see quite a bit of. And also, there has been always, 29A has always been an issue of some amount of controversy, if I may say so, in India. In terms of, it's been the first amendment that was brought to the code, and the one I think that had the most discussion surrounding it. So, what are your thoughts on this?
Yeah, so I've seen a lot of suggestions from different commentators that rather than suspending the ability to initiate under the IBC, maybe 29A can be relaxed so that in this kind of situation, if needed, the promoters could actually come back into the company. So that they were suggesting, for example, that a similar relaxation that has been provided from 29A to small and medium enterprises, which is basically not most of the prohibitions still apply to them, such as a willful defaulter or having criminal convictions and that kind of thing. But the specific ones that don't apply to MSMEs are if they have an NPA, or if they have a corporate guarantee that has, or a personal guarantee that has been invoked. So in those situations, which would be the ones that would apply to most existing shareholders and promoters? So that is something that's been talked about. I don't know, again, I think it would be a big step to actually reverse 29A to this extent, because it was, as you said, Arjun, passed one of the very significant amendments that was made to the IBC. So I think it'll be difficult to step back on this. The other points here, I think there will probably, we will see more out of court restructuring, partly because of the suspension and also because it might just be harder to arrive at a resolution plan through the IBC. We'll probably see some changes to the prudential framework for stressed assets as well. It'll be interesting to see if the RBI comes out with other norms also for smaller accounts, because currently it deals only with larger accounts. The only other point, and this is a slightly different point, which is something that other jurisdictions have done as well, is we'll also have to think about not just what happens in terms of the payments and defaults and companies going into insolvency, but also in light of COVID-19, there may be otherwise economically sound businesses that have a liquidity crunch at this time and may be in need of financing. And one suggestion that various people have made is perhaps, to induce banks to provide financing in these cases, to actually accord some sort of priority status in insolvency for financing given during this period. Of course, the details of this kind of thing will have to be worked out in terms of what is priority financing, what companies would qualify for it, during what period, etc. So these are just some things that we may see going forward.
Yeah, I think for those of our viewers who are not familiar with what priority financing means, it means that this is monies, of course, that are lent in times of hardship as far as the business are concerned. I think this is one of those times. And they have priority over the other loans that are given or the other debts that the company may have. So, and they get repaid first out of the assets of the company, whether it's through a resolution plan or through the liquidation process. But the distinction perhaps that may be drawn, and if it is done, and I would like to see this, is that the cost of financing generally for a company that's already in distress is usually on the higher side, because it is supposed to be a risky transaction. But in this case, a high cost or a high cost burden in any event, I think, would be difficult for a company to bear in the COVID situation. So likelihood is that it will be government or government entities that will be doing most of this kind of financing, and the cost, we hope, is somewhat reasonable.
That's helpful. Thanks, Arjun. Shall we go to questions now?
I think we could take some of the questions that are there.
Just bear with us for a minute. So somebody has said, if a company committed a payment default within ₹1 crore prior to the lockdown and demand notice was issued prior to the lockdown, but section happens next.
So I think right now, as things stand, nothing is stopping anyone from actually, there's no bar to actually filing the application. The only problem is the practical hurdle, that you would have to show some urgency in actually filing that application. So that's the practical aspect to it, and there's no legal bar to actually filing that. The problem, of course, is this thing about 1 crore. So I think the question is, if the default is below the 1 crore limit. Now again, this is something that it's related to the question that was raised earlier about retrospectivity and prospectivity. So how will this be? If the demand notice, my view is that if the demand notice is seen as the trigger for an operational creditor, then certainly I think it should be. If the demand notice has already been sent out prior to all this, then you should be able to move that application. Similarly, for a financial creditor, if the default and the RBI notifications also tend to suggest this, that it's not it's only the defaults that have happened after 1st March that are covered by the notification. If that is the case, then, and we are looking at it as a prospective application, then those applications possibly can also be filed. But if the default takes place after the 24th of March, then I think that it would be subject to that limit. I hope that's answered the question.
Yeah. Then it says, can a successful bidder whose bid is approved by COC but pending approval from adjudicating authority can reduce the bidding value or move out of the resolution process? What are the options available to such bidder? So under the code and also in terms of the representations and agreements that the bidder makes with the COC, once the bidder has made a bid, submitted a resolution plan, usually cannot back out. That said, this has been done in practice. And I think practically speaking, if this happens, then the bidder would lose their earnest money deposit or whatever they have put in. Beyond that, to the extent whether it can reduce the bid value, that is, it's not provided for directly in the IBC, but practically maybe it can be negotiated with the COC. Of course, once the application has been made to approve the plan with the NCLT, I think it's much harder to make any of these changes. Arjun, do you have thoughts on that?
No, I think you're right that once it's already in the pipeline, then wriggling out of it, or before the NCLT, then wriggling out of it may be difficult. But given the circumstances we're in, I think that anything is possible. I think that the NCLT may take a more liberal view if people want to back out, even if it is at the final stage, because I think everybody realizes that the money, that the situation has changed quite dramatically. The other question that is there is, was the suspension of Section 7, 9, and 10 really required, given the fact that timelines and threshold have already been increased? That's a good question. But I think what the government is really looking at is what will happen after the lockdown is lifted. So things will not immediately return to normal, and there will be a certain amount of distress because for businesses to get going from scratch will be quite difficult. For people to have liquidity will take some time. I think that's what the government is really looking at in terms of, or the regulatory approach is that it would be a good idea to stall IBC just for a period of about 6 months so that the economy can get back to some kind of semblance of normalcy.
Yeah, and I think in terms of the threshold being increased, that's not likely to help a lot of, it's unlikely to help a lot of businesses because the 1 lakh threshold was already quite low. So probably the government felt that just increasing the threshold to 1 crore alone may not prevent a lot of other, may not really help other businesses that are larger businesses, as well as smaller ones that have, defaults or dues in excess of that. So I think they perhaps they thought this was not enough. That said, it's going to have a lot of knock-on consequences as well. It will help borrowers, but it will also have a lot of knock-on consequences, especially to operational creditors. We'll move on to the next.
Yeah, Aparna, there's another question. I think you have been working on this for some time. So, what about NBFCs and other financial service providers? Where do they stand?
Yeah, so NBFCs and other financial service providers. And I think this question is about insolvency proceedings against NBFCs and financial service providers. So again, here, and these insolvency proceedings can be initiated against NBFCs only if they are so notified by the RBI, and you need to get the approval of the regulator, in this case the RBI. So it's been done, as you all know, in the case of Dewan Housing. But they haven't really talked about suspending initiation in this situation. So I think we'll have to see what the ordinance says, because you can't really make a section 7, 9 or 10 application to initiate a proceeding against an NBFC for insolvency. That said, this has to be done entirely through a different route in terms of getting regulatory approval for it. So possibly it may continue, but the possibility under the code itself to initiate this itself is quite limited. It only happens where the NBFC is facing a systemic issue and the regulator decides that insolvency resolution makes sense.
Another question is, someone wants to know what is 29A. I think the 29A is a provision by which effectively the earlier promoter group and related parties of the corporate debtor were kept out of the process of bidding or filing any resolution plans for a corporate debtor who was in distress. And I think the idea was that the cure cannot be worse than the disease, in a manner of speaking, so that the people who had sort of gotten the corporate debtor into the situation should not be allowed to get back in or unviable. So that's what Section 29A is about.
Yeah, that's correct. Somebody has also asked, could you please explain the RBI circular and its impact on asset classification? So under the RBI circular of June 2019, if a resolution plan cannot be outside the IBC is not achieved within 180 days, you may remember that previously there was this idea that banks would have to be forced to file IBC proceedings. That whole process doesn't exist anymore. But what they would have to do is increase the provisioning for that particular asset by an additional 20%. So now the latest change gives banks an additional 90 days to arrive at this resolution outside the IBC before they have to take a hit in terms of their provisioning. Just bear with us. We're just looking at the other questions.
Yeah, I think there's one question again regarding interim finance. So I think someone has asked, hasn't 515 of the IBC been amended to notify interim finance and good? But that is correct. It has. But what we are possibly looking at is interim finance to someone who is already in the insolvency resolution process, and that of course has priority. But we are possibly talking about not only that category of finance, but the other finance that the government, or other kinds of loans that the government is proposing to be made available to businesses in distress, and whether that would be recoverable also on a priority basis. And of course, the one thing about interim finance, like you mentioned earlier, is that it is considered to be a very risky loan. And therefore, it comes with a cost attached. We don't know if priority financing in COVID times is going to be of similar nature or not.
Yeah, that's right. So, and I think also interim financing under the IBC, it's financing provided during the CIRP period.
Yes,
right?
After the admission.
It's slightly broader in terms of covering other kinds of emergency financing.
There is also an interesting question whether mediation can be successful in corporate insolvency. Well, I think that this is again quite an important question. But there are not very many sort of routes out of corporate, the corporate insolvency resolution process. That the scope for settlement after a point becomes quite limited. So if there is a settlement between the corporate debtor and the promoter group of the corporate debtor and the creditors prior to the constitution of the committee of creditors, that doesn't require the approval of the committee of creditors, and application can be moved. But if the committee of creditors has been constituted, and usually it is done within a fortnight, of the admission order passed by the NCLT, then there is a problem because you need 90% approval. So so therefore that's a situation where mediation has a limited role to play in this situation.
Then I think there's a question. Do you anticipate that the ordinance will exclude lockdown period from the time period of 1 year under 29A? I think that probably would make sense. We haven't seen it as yet, and probably people haven't thought about those details as yet. But I think that because the lockdown period is otherwise excluded from calculating various other time periods for CIRP proceedings, it would make sense for it to be excluded from when you're thinking about the time period under 29A as well.
Another interesting question, Aparna, is that do we see online COCs being conducted in the near future? And I think the answer is that we have already seen a few online COCs being conducted. And even before the COVID-19, we had COCs that were being held through video conference. So I don't think that actually holding of COC meetings is really been impeded because there are enough. I think more on the side of the resolution applications. Yeah.
Yeah. Okay.
And there are other problems. Not being able to approach courts for those kinds of things. That's not the actual COC.
Then somebody has asked an interesting question. The relaxations and extensions of timelines, claim amounts, and asset classification. Is there a chance that the burdens might shift to DRT? Very well could. We don't know, but because the DRT avenue will still remain available. Unless there are other changes to encourage more out of court debt restructuring or changes to the prudential framework, I think that's it. Arjun, can you? Okay.
Yeah, yeah. I think there are quite a few questions, but I think have run out of time. So that is the major problem. It's 5 o'clock now. We will try to address some of these questions over email if possible. So you'll have to bear with us because we've got, and we must thank everyone for the overwhelming response to this particular webinar. Aparna?
Yeah, no, thanks, Arjun, and thanks everyone for attending and also asking a lot of very interesting questions. Sorry, we've run out of time, but they're definitely going to be, this is a space that is very fluid and there are going to be a lot of developments that we are tracking closely. So I'm sure we will be keeping you updated on this as well. Thank you very much, everyone.